The first one is People versus Christopher Sindone. It is a mini oral argument on the application. You each have 15 minutes. Ms. Dunne, you may reserve time for rebuttal, but we will ask you to try and keep track of that and police it yourself. And with that, you may proceed.
Thank you. I will reserve my 2 minutes, but I'll keep an eye on my clock. Thank you. It's Kristina Dunne for Christopher Sindone. And Your Honors, I think the question here is quite clear. It's whether or not the legislature in 1931, when they enacted these statutes, preparation to burn statute and the arson statutes, intended preparation to burn to be a lesser included offense. And if they did intend that, what kind of lesser included offense was it? And I believe that after reviewing all the statutes and the law, that I can safely argue that they truly intended this to be a type of attempt, that preparation to burn was a codified attempt at arson. It may not even have met quite all the elements required for an attempted arson, which is still allowed under our general attempt statute, which was enacted in the same year, but it is a kind of attempt. And I believe that we can come to that conclusion if we go back to the Miller case, which we were directed to address in this case in Sindone. And in Miller in 215, this court found that if you look at the other statutes that are enacted as a package, that you can determine whether there is clear legislative intent to have a certain crime be a lesser included offense or not, based on the whole legislative package. And in this case, I would argue that looking at everything that was enacted in 1931, and it's a lot of our codified criminal law, that the legislature really did do that. They also codified some other special attempts, including attempt to murder, and that's MCL 759-1. And that statute is very clear that if you don't commit an assault, you can still attempt a murder. And they codified that in addition to having the general attempt statute, because they wanted to make sure it was clear that you did not need an assault to attempt murder. They also had a special assault with intent to murder codification. That's MCL 758-3. And in that statute, they talk specifically about the kind of attempted murder that includes an assault. So they really made very clear in some other situations that there is something beyond just an attempt. And they wanted to codify preparation to burn for the same reasons, especially if you think historically, arson's a very difficult crime to complete in many ways. And they wanted to make sure that taking steps towards an arson were also punishable under the law. And that's why they enacted a pretty in-depth preparation to burn statute. I mean, this is a lengthy statute from 1931, 750-79 MCL. And I think they set out very clearly there's lots of ways in which you are violating the law, even setting up a fire, even if it never is actually ignited.
Why don't I interrupt you here, Ms. Dunne, and see what questions folks have for you. So Justice Cavanagh. You are muted.
Yeah, sorry. I don't have any questions this morning.
Justice Welch.
No questions this morning.
Justice Viviano.
All right, thank you. Counsel, I guess I'm interested in your response to the prosecutor's hypothetical.
Yes.
About a fire that starts negligently, but that a person could stop and does not stop. I guess I got stuck on that in terms of, isn't that another way that that the crime could be proved?
Well, Your Honor, I went back and looked at that case. It's actually not a case that she cites. She cites a law. It's kind of a law review kind of document from 1951 called "The Crime of Arson" from Criminal Law and Criminology. And again, I don't think that our legislature was in the habit or practice of thinking of wild kind of random hypotheticals. They really were focused on the mens rea to commit a fire or to cause a fire in the arson statutes. They did not make any comment at all in the statute anywhere about negligence. In fact, we know from other case law from that time period that negligence was not considered a crime, and that this citation to a hypothetical is not really what our legislature was thinking about, and not in their intent. And that's really what this court is here to decide, whether or not the legislature intended something like negligence to fall under the criminal statute. I actually, in researching my argument for today, I went back to a lot of older double jeopardy cases from this court, and I read some of them, and I found this case that I think has some interesting language that I think the court could look to, and that's People versus Robideau, and it's Robideau from 1984. 419 Mich 458. And in Robideau's kind of funny because it kind of predicts the demise of the Blockburger standard in a way. But one of the things they state, and I think this is important for the court to consider, that statutes prohibiting, and this is from page 14 of my document, I'm not sure what page it would be in the actual book, statutes prohibiting conduct that is violative of distinct social norms can generally be viewed as separate and amenable to permitting multiple punishments. A court must identify the type of harm the legislature intended to prevent. Where two statutes prohibit violations of the same social norm, albeit in a somewhat different manner, then as a general principle, it can be concluded that the legislature did not intend multiple punishments. And in this case, that's exactly what we have. The social norm that's being proposed or prohibited would be this the problem with setting a fire that actually becomes a fire. That's the same problem that it's addressing. So it is really a lesser included offense of the completed arson, because it's not trying to prevent something different from happening. It's really just trying to prevent the entire arson from happening. And in a special way, in the special kind of attempt that's really before any ignition ever takes place. I don't know if that answers the question, but.
Well, it's a difficult question, but really the idea is if there is no textual indication in the statute, I think that's what Miller teaches, then we have to apply the test and try to determine if there is another way to commit the crime that's different than the primary arson offense. But that's all I have. Thank you, counsel.
Thank you.
Justice Bernstein?
Good morning, counsel. Happy New Year. And my New Year's gift to you is I have no questions.
Oh, okay. Thank you.
Justice Clement?
No questions.
Counsel, you have some time left. Do you want to reserve
Yes.
for rebuttal? Or?
Well, actually, if I just may address a couple other points from the prosecutor's pleading, since I imagine that that's where we'll go with this argument. So one of the things the prosecutor argues in her pleading is, and this is from page 29 of the plaintiff's, of the appellee's supplemental brief, is she states the real question, this is the very bottom of the page, the real question is whether it is impossible to commit the greater offense without committing the lesser offense. That's not the real question. The real question is whether or not the legislature intended this preparation to burn statute to be a lesser included offense of arson. I argue they did, not whether it's impossible. That's not the test. In fact, I think we should get away from crazy law school hypotheticals when it comes to arson and think about the mens rea of the perpetrator and what the legislature intended to prevent by enacting these statutes. She cites a case for that principle, People versus Dickinson, which is from 2017. It's a Court of Appeals case, 321 Mishap 1. And where the Court of Appeals held that a person could be convicted of both possession of heroin and delivery of heroin. And in that case, the Court of Appeals found that you could be convicted of both. And I argue that is a correct decision. And that it's not, though, a basis for deciding whether or not, in this case, the Sindone case, preparation to burn and the completed arson are both punishable. Because they're not about violating the same social norm. Preparation to burn and arson are violating the same social norm, but possession of heroin and delivery of heroin are two different things that we are concerned about. Possessing heroin alone can lead to trouble, right? People can be robbed. They can use the heroin. They can do any number of things that they could have a lot of money on their person because they're trying to buy heroin. But delivery of heroin is a special social norm, a different social norm that we want to prohibit. So I would say that's really not applicable in this case. It's not about the same problem that we're seeing in Sindone, which is that the statutes were enacted to prevent the same social problem. The other point I would like to make about the prosecutor's brief is that she talks about a case from, again, it's from 1971 and it's a Court of Appeals case. So I don't think it has a lot of precedence that apparently held that both conviction for arson and preparation to burn could be upheld, and that they were not void for multiplicity. And this is on page 33 of her pleading. And again, I just don't think that case, we don't know enough about the facts of that case from its opinion, first of all. And I don't think that case is what we're talking about in Sindone. It also is a very old case, and there's been so much law developed since then on double jeopardy principles that I think it should not be viewed as binding precedent.
With
So
that,
then I would
like
reserve my
reserve?
rebuttal.
Okay,
Yes.
thank you. Thank you, Ms. Dunn.
Thanks.
No problem. Ms. Cretu, you may proceed.
Good morning. May it
Morning.
please the Honorable Court, Mary Casey Cretu on behalf of the people of the state of Michigan, County of Wayne. The people submit in answer to the questions this court has posed to the parties. First, that the second-degree arson and preparation to burn statutes do indeed express a clear legislative intent to permit multiple punishments for the same conduct. We know this because when examined as a whole, it is clear that the arson chapter prohibits some, but not all, contemporaneous arson convictions. This court should interpret silence in only some of the arson sections as intentional, not an inadvertent mistake by the authors. In addition, the preparation to burn statute contains language that demonstrates the legislature was aware that it was permitting cumulative punishments for both arson and prep to burn, in that it explicitly contemplates the commission of arson. But even if we assume that the legislative intent is unclear, these crimes still pass the same elements test. The focus of that test, as the name implies, is on the elements, not the evidence or facts of a particular case. Both arson and preparation to burn contain an element not included in the other. While arson requires proof of that property was burned, damaged, or destroyed, preparation to burn requires proof of the use, arrangement, placement, etc., of an inflammable, combustible, or explosive material, substance, liquid, or device. These elements are unique to their respective crimes. And the fact that these crimes each have a unique element means that, contrary to defendant's argument, it is possible to commit arson without committing the crime of preparation to burn, as I cite to in my brief. And it's on these bases that the people respectfully request that this court deny defendant's application for leave to appeal. With that, I don't know if I have any time left in my free fire zone, but I would waive any remaining time and am open to questions.
Thank you, Ms. Cretu. Let me see what questions people have for you. Let me start with Justice Cavanagh.
No questions.
Justice Welch.
No question.
Justice Viviano.
Yeah, thank you, counsel. If we look at your hypothetical that I broached with your opposing counsel, I guess my question for you is, why wouldn't we think of shutting off the sprinkler system as the use of any device?
Because it's not
In other words, using the off switch, I guess.
correct, but it's not, even if it's a use of a device, it's not an inflammable, combustible, or explosive device, as the statute preparation to burn requires.
So you read that second element, it says an inflammable, combustible, or explosive material, liquid, or substance. There's a second or there, or any device. You believe that all those adjectives modify not only material, liquid, or substance, but also or any device?
I would submit to the court that that was the intent of the legislature in writing the statute.
So why did they use two ors?
Well, I guess that's a matter of interpretation. I even if, for example, like I gave one hypothetical in my brief, but there are other ways to commit arson without committing preparation to burn. For instance, if someone opens a window providing oxygen, which is required for a fire to grow, that would be committing arson without committing preparation to burn.
Isn't wouldn't a window be considered a device?
And if you interpret it that way, if someone prevents the fire department from responding to a fire, that would be not using any device and still allowing the fire to escalate or extend further than it would have had the first responders been able to come, and yet not committing preparation to burn.
All right, thank you, counsel.
Thank you.
Justice Bernstein?
Good morning. No questions. Thank you.
Justice Clement?
Good morning, counsel. Just one quick question. You give a lot of hypotheticals to illustrate your point. Do we have any Michigan case law on point that holds that the defendant can be found guilty of arson, but not preparation to burn?
I was not able to find any cases that displayed the example I cite to in my brief or ones that I've mentioned, but that does not negate the fact that the elements, each crime at issue here has a unique element. And not only that, with the clear legislative intent written in the statute, I would argue that just because it has not happened does not mean it violates double jeopardy.
Thank you.
Does anyone else have any additional questions for Ms. Cretu? You have some time left if there are other points you'd like to make.
I just would like to address a couple of things that opposing counsel has mentioned. First, the social norm analysis of legislative intent in Robidoux that she referenced, that case was overturned by People versus Smith, 478 Mich 292 from 2007. And this court in People versus Miller clearly stated what the double jeopardy analysis law is, and it boils down to legislative intent. And if that is clear, their analysis is over. If not, if it is unclear, we move on to the same elements test. And I submit to this court that these two crimes at issue in this case pass the same elements test and the legislative intent is clear. Also, opposing counsel argued that preparation to burn is an attempt at arson. And I would argue to the court that language within the preparation to burn statute, the fact that it contemplates the commission of arson demonstrates that the legislature intended for prep to burn to not be an attempt at arson. Specifically, in the prep to burn statute, one of the ways that it can be committed is if the quote property damaged if quote the fire or explosion results in an injury. The legislature, that assumes the commission of the crime of arson. Also, there's another example in the preparation to burn statute in which the fine that can be assessed cannot exceed 3 times the combined value of the quote property damaged or destroyed. And that language is indicative of one of the elements of arson, the commission of arson. So I would argue that and when we compare the different degrees of arson to preparation to burn, the overlapping elements, the overlapping punishments makes it clear that this is not a logical lesser included offense of arson. And I think that with that, I would ask the court to respectfully deny defendant's application.
Thank you very much. Ms. Dunne, you have some rebuttal time.
Thank you. Yes, I would go back to argue that Miller is absolutely correctly decided that in this case is just like Miller. The legislative intent is clear, and I can say it's clear because I'm looking at this is a large crime bill, and there's a codification of special kinds of attempt, and those are lesser included offenses of the primary offense. For example, the attempted murder, the assault with intent to murder, special codifications of the homicide statute. This is a special codification of an attempt to commit arson. In fact, I mean, the plain language of the preparation to burn statute itself, the very first line is with the intent to commit arson of any degree using a flammable, combustible, or explosive material, liquid, or substance near a building or personal property with intent to commit arson of any degree. It's clearly a lesser included offense. I would also argue that in my own practice, I have had arson charges, attempted arson, that's charged in the alternative with preparation to burn, under the theory that they may not be able to prove attempted arson. They may only be able to prove the preparation to burn. These are, and that was out of Oakland County. It's a case that's still pending, a defendant who has yet to be sentenced. That's the proper way to use these statutes. That's what the legislature intended. And with that, I don't think this is a complicated issue. The court's already decided it in Miller, and it should decide the same way here. And if the court chooses to grant the application, obviously we can delve into this deeper, but I think the court has enough to decide the issue for my client at this time.
Are there additional questions for Ms. Dunne from anyone? Not seeing any. Thank you both, counsel, for your presentations. The case will be submitted.
Thank you.
Thank you.